Welcome back to the Emily Show, Law Nerd. We have a lot to talk about today with regard to the Netflix video. It's not a docuseries, it's not a documentary video. It's not really a movie because it's about as long as, well, a normal episode of this podcast. But you have been asking me about the crash, and today we are going to talk a bit about it. So if you are familiar with this particular video or others that have covered it, because there have been episodes of numerous shows that have covered the prosecution of Mackenzie Shirilla, then don't worry, we are going to cover new stuff. If you are not familiar with this video, case, documentaries about it, don't worry. I'm going to give you the background that we need to talk about the appeals today, because I am so curious about what's going on, because there is a fight brewing at the Ohio Supreme Court over this case. And I'm really curious about what's happening, because every time we cover a case, law nerds, we are blessed with the fact that we get to talk about something that I have never seen before. And today is also one of those days, because there is something in this appeal that I have actually never seen argued before. And I want to talk to you about it. So if you are curious about the appeals going on in this case and what happens next, don't worry, I've got you covered. We're going to take a look at what's been filed in court and stick to the facts, because it seems that there's a lot of other stuff that has happened in this case. And I know there is no way I am familiar with all of it because, well, I took a look at the Netflix episode when y'all started asking me about it and people started talking about it, because I didn't cover this case when I was covering other things when it happened in 2023. So today is our day to dive in together. So let's get into it. I'm legal analyst Emily D. Baker, yes, also a lawyer, and this is The Emily Show. I break down the pop culture, entertainment, and high-profile cases that we're all talking about. I know you want the facts, so let's get into it. And Law Nerd, don't worry, we've got a lot going on this week. There are about 5 other things that I wanted to cover on the podcast, and I'm like, no, they're going to have to wait for stream. And remember, this coming week, because it's June, right? Who knew? It's June. This coming week, we are going to have International Law Nerd Cookie Day Take 2 on Friday, June 5th, because we will be together for the sentencing of Brendan Banfield. So don't forget to get the Law Nerd app so you stay in the loop with that sentencing coming up on Friday. There's a lot to cover on stream this week, and you're not going to want to miss any of it. Today, let's talk about the crash and the prosecution of Mackenzie Shirilla. I'm going to give a quick road so far overview of this case, and the appellate court gave a really detailed recitation of the evidence in this case. I'm going to post a link to that here, and the document will be available for download in the Law Nerd Lounge in the app if you want to download that and look at it. But it has been covered so much that I felt that the overview was probably most helpful as we get into the appeals. A quick overview of this case. Mackenzie Shirilla was prosecuted and convicted for the fatal July 31st, 2022 crash that killed her boyfriend, Dominic Russo, and their mutual friend, Davian Flanagan. At the time of the crash, she was 17 years old. She is now currently 21. She was tried in 2023, and there's been a lot of conversation about this trial, especially in light of the Netflix series, because that was a court trial, which is an interesting choice. We don't see a ton of prosecutions that are a court trial, but the defendant has the right to waive a jury trial and just have the judge decide. That can be done for a variety of reasons, including if this case was particularly sympathetic, which I think that it probably was, and the community had a tremendous amount of sympathy for the young victims, Davian Flanagan and Dominic Russo, who seemed to be well known and well liked within the community. And if you want to focus on a particularly narrow aspect of law, in this case, it's going to be intent. And if you saw the crash, you will see that Mackenzie Shirilla gave an interview for the first time to Netflix. And I think that that was an interesting choice, but her fervent hope is that everyone understands that this was unintentional. This was not intentional. It was unintentional. She doesn't remember what happened, but it was unintentional. And I don't throw too much shade at her saying she doesn't remember what happens. That's not uncommon in serious and fatal and near fatal vehicle collisions. It is pretty remarkable that she survived this collision. And there might be things that she doesn't remember. I don't know if everyone believes that, but that's not really the point for today. However, at the time of the crash, she was 17 years old. This case was taken from a juvenile prosecution, and in California, we called it certified up, but it went through the process to move it from juvenile to adult. One of the questions I had is that in interviews with the prosecution, we saw the prosecution talking about this being an aggravated murder, being originally charged as that kind of murder plus, but it didn't go to trial that way. And it turns out that in the process of moving it from juvenile court to adult court, the juvenile court did not find that they had met the threshold for an aggravated murder. So when it went forward to adult court and to be prosecuted and tried in adult court, those charges weren't even presented to grand jury because the juvenile court had removed them and the prosecutors did not add them back in. If they were even able to do that, I think that's probably the right choice, given the circumstances of this crash. So in 2023, she had a court trial. I imagine that was so the defense could focus on that narrow aspect of intent, but the court found her guilty of all the counts that she was facing, which were a substantial number of counts, including 4 counts of murder, 2 different murder theories for 2 different victims. So 4 counts of murder. Of course, she can't be sentenced on those. All they merge, but there were 2 different theories of murder. One being felony murder, that the murder happened in the course of another felony. She was also convicted of 4 counts of felonious assault for the driving here, and 2 counts of aggravated vehicular homicide, as well as several drug-related crimes. But there were 3 different theories, essentially, of murder that she was facing at trial, and that included a unlawful killing of another, the killing of another during the course of the collision, during the course of the felonious assault in the collision, and then the 2 counts of aggravated vehicular homicide and the drug counts. She was ultimately sentenced to concurrent, that means at the same time, 15-year to life sentences, which means she'll first be eligible for that in 2037, but at some point she'll have to sit before a parole board and indicate that she had good behavior while in custody. She has not gotten in trouble while in custody. She has rehabilitated. She has taken what she has done seriously, shown remorse, and is ready to make different choices going forward. Based on the interview we've seen, which the parole board will be aware of, I don't know if she's there just yet, but maybe that'll change between now and 2037. However, she is maintaining her innocence. The defense has been pursuing numerous appeals, and we are going to be talking about those today because her first round of appeals have already failed and been denied. And this second round of appeals are very interesting to me because the court has deemed them untimely. And the arguments regarding the untimeliness, I am fascinated by. But the facts surrounding this crash involve her vehicle going over 100 miles an hour into the side of a building, a brick wall, no effort to brake, no easing up off the pedal. And we saw the similar types of reports we saw in the Karen Reed case with the black box from the vehicle recording 5 seconds before the crash. And the car never showed any easing up off of the accelerator that was depressed at 100% up until the time that the vehicle hit the wall. So other arguments that have been posited in the docuseries, though were not brought up in trial, were whether or not she had a medical emergency. However, I don't find discussion of that super helpful in our purposes because the defense did not present experts to determine and present evidence that there was a potential medical emergency that caused this crash. And because that was not presented at trial, it doesn't factor into the appeals here. So it's not really for us to determine, because if there's a defense there, my thought is that the defense would have presented it. And there's always the possibility that they could not find an expert to say that this was, in fact, something that could have caused this collision. So let's talk about these appeals. The first appeal I am just going to refer to as the appeal on the merits instead of referring to it by its final numbers, which are 6-7. I know, 6-7. I know. We're going to call it the appeal on the merits. That's the appeal that we've covered in a lot of other cases where the appellate lawyers bring in a list of the trial court ruled this wrong, the trial court didn't do that. An appeal based on the merits of the case. That is different than the appeal that is going forward now. The appeal on the merits of the case was determined in September 2024, and spoilers, the conviction was affirmed. Otherwise, we wouldn't be talking about another appeal going forward, would we? I want to look real quick at just what points the defense was arguing in bringing this appeal. And to do that, we are going to take a look at the table of contents here, which gives us a really good overview of what the arguments were brought by the defense, because I've seen a lot of questions from the law nerds, because the law nerds are, you guys are smart. You know the law. You're curious. What are they appealing? Are they asking for ineffective assistance of trial counsel for not bringing a defense about a medical or potential medical event? What are they arguing on the merits? Let's take a look. Their first argument, which is called assignment of error in Ohio, is that the juvenile court erred when it concluded that the state presented sufficient credible evidence to demonstrate probable cause to believe that Shirilla purposely and or knowingly caused the deaths of the victims. So the first argument is that this shouldn't have been found to have met enough evidence to get from juvenile court to adult court to be tried. Remember, the juvenile court did remove some of the murder counts that had originally been filed. Their next assignment of error is that the state failed to introduce sufficient evidence to sustain the convictions in violation of Shirilla's right of due process. There's not enough argument. There's not enough evidence here. There's not enough evidence presented by the state. There's not enough evidence here. This violates the constitutional rights. Insufficient evidence. The next assignment of error is that the convictions are against the manifest weight of the evidence, which is another way to argue that essentially the trial court got it wrong in their verdict. Not enough evidence here. The next assignment of error is that the trial court erred by permitting the state to introduce character and or other acts evidence during its case in chief. This is similar to the arguments that we saw in Murdaugh. Too much financial crimes in Murdaugh was something that the court noted, though it's not the reason Murdaugh's conviction got overturned. But this is one of those areas where if character evidence comes in and if other acts evidence comes in, it can be an area where you see a conviction overturned. However, that's harder to do when you have a bench trial. The worry is that jurors can't separate these things in their mind, that jurors are going to look at something that's unflattering of a defendant and be like, well, yeah, they probably did the thing. Generally, they suck. They probably did all the things. That is improper character propensity evidence. Hey, they probably did the thing. But when you have a bench trial, other judges are going to look at that and say, no, the court can separate these things out in their mind. The court is not going to take character evidence, look at the person before them, and have the same potential impact that a jury might. So when you are looking at arguing this on appeal, this argument might go a little further at a jury trial. Then again, the court might make different rulings at a jury trial. Because at a bench trial, the court can say, I can separate these things out. Tell me what you want to tell me. And the final argument that they brought on this appeal is that the trial court erroneously precluded the defense from introducing testimony and or evidence relating to the July 17th incident, thereby prejudicing Shirilla's constitutional right to due process and fair trial, as well as her right to present a meaningful and complete defense. This is regarding a prior incident where it is alleged that Shirilla was overheard saying that she was going to crash the vehicle while she was in the vehicle driving and in a fight with Dominic Russo. Now looking at the Court of Appeals, as they are talking about upholding the conviction, they get into the sufficiency of the evidence, saying, quote, Shirilla contends that her convictions were not supported by sufficient evidence. While she challenges the convictions on each of counts 1 through 8, we note that counts 2 and 8 are merged into other offenses at sentencing. Therefore, any error with respect to the sufficiency or manifest weight of the evidence on those counts is harmless beyond a reasonable doubt because they merged, so she can't be sentenced on them. And then they go on to say that an appellate court's function when reviewing the sufficiency of the evidence to support a criminal conviction is to examine the evidence admitted at trial to determine whether such evidence, if believed, would convince a reasonable juror of the defendant's guilt beyond a reasonable doubt. And then they take a substantial amount of space lining out the evidence that they believe is not just sufficient, but beyond sufficient, including the incident a month before the crash where Shirilla was heard threatening to crash the car while they were driving. That's an earlier in July incident. That medical experts examined Shirilla after the crash and could find no evidence that she had been afflicted with a neurological or muscular condition that would have contributed to the crash, that the car was not malfunctioning. They go on to say this evidence was sufficient for the fact finder to conclude beyond a reasonable doubt that Shirilla crashed the vehicle purposely, intending to kill Flanagan and Russo. We therefore overrule Shirilla's second assignment of error. The court concludes saying, having overruled Shirilla's assignments of error for the reasons we stated above, we affirm. That means they uphold the conviction. The court finds there were reasonable grounds for this appeal, which means this wasn't a frivolous appeal. There were grounds to be examined by the court. They say it is ordered that a special mandate issue out of this court directing the Cuyahoga County Court of Common Pleas to carry this judgment into execution, meaning that her appeal has been essentially denied. The defendant's convictions having been affirmed, any bail pending is terminated, which was probably already done given the sentences, but might not have been. So in September of 2024, the Court of Appeals denied the appeal, affirmed the conviction on the merits. And then you had a subsequent appeal noticed in the trial court. And that is where we hit some interesting legal arguments. Leonard, we're going to take a quick moment to talk about something that I love as much as talking about these cases with you, and that's the Leonard Shop and today's sponsor, Shopify. Because without Shopify, the Leonard Shop wouldn't have happened. From starting this shop in, the middle of the night at the speed of ADHD and building it myself, to growing it to where we're at now. And one of the things I know that you love, that I love too, is the Shop Pay button. It makes it so easy to check out because you don't need to get out your wallet. You don't need to log in. It's all just handled and secure. Shopify makes it so easy to design your own site with their built-in studio with hundreds and hundreds of ready-to-use templates. So your shop doesn't just look like everybody else's, but also it's really easy to get it up and running, and it matches you and your brand style. They have world-class expertise in inventory and international shipping, plus they can handle your returns, and if you ever get stuck, they have 24/7 customer service. Leonard, it's time to see less carts go abandoned and more sales go with Shopify and their Shop Pay button. Sign up for your $1 per month trial today at shopify.com/Leonard. That's shopify.com/Leonard. Thank you, Shopify, for sponsoring today's episode, and let's get back to the podcast. So after the appeal on the merits was complete, Shirilla filed an additional motion for post-conviction relief. The post-conviction relief was denied by the trial court. That denial was based on it being untimely. That went back to the Court of Appeals. And in March of this year, the Court of Appeals denied the requested relief. And now this is going to the Ohio Supreme Court, asking the Supreme Court to overrule what the Court of Appeals did, which was uphold the trial court's denial of the post-conviction relief. So we're going to take a look real quick at what the Court of Appeals said just in March of 2026, denying the relief requested for the defense. And then we're going to take a quick look at what the defense is arguing to the Supreme Court of Ohio, because this is now pending currently before the Supreme Court of Ohio. In fact, the prosecution's brief on this, or the state's brief on this, was just filed early in May 2026. So this is still pending. However, this is a difficult road for the defense on this untimely appeal. So this is the entry of opinion from the 8th Appellate Circuit Court of Appeals from March 12th, 2026, saying that the defendant appeals from the trial court's entry dismissing her petition for post-conviction relief as untimely for the reasons that follow. We affirm the trial court's decision. They are upholding what the trial court did. They say the underlying convictions stem from a high-speed automobile collision on July 31st, 2022 in Strongsville, Ohio. Shirilla, then 17 years old, drove her vehicle at speeds reaching 100 miles an hour before striking a brick building, resulting in the deaths of her two passengers. Following a bind-over hearing from juvenile court and subsequent bench trial in the Court of Common Pleas, Shirilla was convicted of 4 counts of murder, 4 counts of felonious assault, 2 counts of aggravated vehicular homicide. She was sentenced to an aggregate term of 15 years to life in prison. This court affirmed her convictions on direct appeal. That is the appeal that we just talked about. During that direct appeal, the trial transcripts were filed on October 23rd, 2023. Transcripts from the juvenile court bindover proceedings were filed later on December 15th, 2023. On October 24th, 2024, Shirilla filed a petition for post-conviction relief. In the direct appeal, the clerk docketed the criminal trial transcripts as filed on October 24th, 2023. Those dates matter. The trial court dismissed the petition as time-barred on May 1st, 2025, concluding it was filed 1 day past the 365-day jurisdictional deadline. Untimely. Emily, what does jurisdictional deadline mean? It means that the jurisdiction of the court to hear the case expires, essentially, after 365 days. And the issue is not that they were filed the 23rd and then the clerk did not docket them until the 24th and they were filed on the 24th. I know it might seem that that's the issue. That's not the issue. The defense is arguing that the issue is the leap year. And we're going to get to that in a minute because that's the argument. The court accounted for the transcripts being docketed October 24th, 2023. But literally waiting till the very, 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 very last day, which wasn't even the last day, on October 24th, 2024, is the problem because it's not the anniversary. It is 365 calendar days. And there should be software that the attorneys would be aware of to make sure that you do not miss the deadline. These are the assignment of errors for this appeal. Shirilla raises the following assignment of errors. The trial court erred when it concluded that the petition to vacate or set aside convictions was untimely. Any error in calculating the deadline for filing the petition to vacate or set aside the convictions should be excused. Oh boy. The court goes on to talk about when the clock essentially starts. They call it the trial transcript trigger. They say that in Shirilla's first assignment of error, she contends that the trial court erred when it concluded that the petition to vacate or set aside convictions were untimely. Shirilla argues that the 365-day clock did not begin until December 15th, 2023, when the juvenile bindover transcripts were filed. The state conversely maintains that the clock was triggered on October 24th, 2023, the date that the clerk noted and docketed the trial transcripts from the criminal trial. The state argues that a trial is a proceeding to determine guilt or innocence, and therefore the probable cause hearing does not fall under the definition of trial. The appellate court goes on to say that turning to the merits, the record reflects the trigger date was October 24th, 2023, and the deadline for post-conviction relief was on October 23rd, 2024. The Ohio Supreme Court reiterated that the deadline for filing a post-conviction petition is tied to the filing of the trial transcript in the direct appeal, and that untimely petitions are barred unless the petitioner satisfies the exceptions under RC 2953.23. The Supreme Court has said repeatedly, it seems, in case law, that that date is a firm date unless there are exceptions. They go on to say that in another case, the court emphasized that the 365-day period begins upon the filing of the trial transcripts in the direct appeal, or if no appeal is taken upon the expiration of the time for filing the appeal. Under the rules, it is required that the post-conviction relief petition be filed no later than 365 days after the date on which the trial transcript is filed. In computing that 365-day period, they say Ohio's general computation of time statute applies. Under RC 1.14, when a period of time is expressed in days, the day of the act, event, or default from which the designated period of time begins to run shall not be included, but the last day of the period shall be included, unless it falls on a day the public office is closed. in which case the period extends until the next day the office is open. So if this files on a holiday or a weekend that it's closed, then it extends till the next day. Accordingly, putting aside Shirilla's contention that the calculation was altered because 2024 was a leap year, the 365-day deadline is determined by excluding the transcript filed date and counting forward 365 days, including the final day. Not excluding, including the final day. The statutory deadline is jurisdictional, meaning that the trial court lacks subject matter jurisdiction to entertain an untimely petition unless specific exceptions apply. The rules tell you how to count, and they tell you which days to include. The day that this is triggered is a 0 day. The next day starts at 1. The final day also is included. The 365th day is the day that it is due, not the next day. The court goes on to address the leap year calculation, an argument I have never seen come up in court. Then again, I don't think I've seen many appeals that wait until literally the very, 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 very last moment to file an appeal, because this can happen, and courts are incredibly inflexible when it comes to these deadlines, especially because appellate courts tend to be incredibly accommodating when asking for extensions of time. And no extension of time was asked for regarding this particular petition. In the other appeal, extensions of time and motions to enlarge time were filed numerous times in the appeal on the merits. The court says, having established October 24th, 2023 as the trigger date, we must address the impact of the 2024 leap year. Shirilla argues that the quote-unquote anniversary date of the triggering event should control the deadline, effectively providing 366 days for filing during a leap year. This argument is misplaced because of a fundamental difference in statutory construction. The General Assembly frequently employs the term 1 year in other contexts to imply a calendar year period terminating on the same anniversary date, regardless of any intervening leap day, meaning they are aware that 1 year would colloquially mean anniversary date, regardless of how many days are in between. The court says in those cases, the computation of time should align with the anniversary date, not the number of days elapsed. And there's case law on it because this comes up. They say a year terminates on the same anniversary date, even in a leap year. The court emphasized that the computation of time should align with the anniversary date, not the number of days elapsed. However, they say, and I also say, however, we all say, the code that they are using here uses the specific term of, quote, 365 days. Ohio law is clear that PCR petitions must be filed within 365 days after the trial transcript is filed in the Court of Appeals, not on the date's 1 year anniversary. In a leap year, the 365th day falls 1 calendar day prior to the anniversary of the triggering event. Because the statute prescribes a deadline in days, not years, the court must apply the 365-day count as written. Honestly, I can't see the Supreme Court varying from this either, because A, there's case law on it, B, the statute is incredibly clear, C, the construction of the statute is incredibly clear. I can't see the Supreme Court wavering on this jurisdictional deadline. The court goes on to say that counting from October 24th, 2023, the 365th day fell on October 23rd, 2024. Shirilla filed her petition on October 24th, 2024, and the petition was therefore untimely. I do not think we will see the Ohio Supreme Court vary on this. Emily, what's going to happen then? Well, then I imagine we will see a different appeal filed for ineffective assistance of appellate counsel, and I don't know if that will fly either. But I think in this scenario, the client is going to turn around and blame the lawyers, because ultimately, this is the lawyer's fault. Miscalendaring on a very clear deadline with no wiggle room left, filing this at the, well, not 11th hour, the 13th hour in this case, is on the lawyers. But this is also the thing that courts are incredibly set in, because it's a jurisdictional deadline. And once the jurisdiction is lapsed, they can't hear it. The court goes on to say that because the trial court lacked subject matter jurisdiction to entertain an untimely petition, we need not address whether Shirilla waived any of her timeliness arguments. The court cannot hear it. They go on to say the defendant seeks equitable tolling based on excusable ignorance and the confused state of the law regarding leap years, citing federal habeas cases to support this equitable authority. The defendant's reliance on federal habeas equitable tolling principles does not apply to petitions for post-conviction relief governed by these statutes. They go on to say that Ohio courts have consistently held that the trial court lacks jurisdiction to adjudicate an untimely petition unless the petitioner satisfies one of the exceptions set forth. The exceptions require the petitioner to demonstrate either that they were unavoidably prevented from discovering the facts necessary to present their claim, or that a new federal or state right recognized by the United States Supreme Court applies retroactively. Those exceptions do not apply here. The exception that there was an undiscovered fact, that new evidence came to light after 365 days, doesn't apply here. They're not even arguing that it applies here. They're arguing a calendaring error, and that does not fall within the exceptions. Their conclusion is, because the filing of a post-conviction petition is a jurisdictional act and the exceptions for delay set forth in the statute are not satisfied, the trial court lacks the authority to apply equitable tolling to excuse even a one-day delay. The post-conviction relief petition was filed on the 366th day following the filing of her trial transcript. Accordingly, we find that the trial court correctly determined it was without jurisdiction to consider the petition. Finding no error in the trial court's application of the jurisdictional 365-day mandate, both assignments of error are overruled. Judgment affirmed. The Court of Appeal has said, we cannot hear this because there's no jurisdiction. The trial court lacks jurisdiction on the post-conviction relief. They can't consider the merits of it because it is untimely. So there is a bar to even being able to look further at the merits of the request for post-conviction relief. And this is in a circumstance where an appeal on the merits has already been denied. It's not as if her appeal on the merits has not been heard and will not been heard. Her appeal on the merits has been heard, but they are asking for additional and other post-trial relief different than their appeal on the merits. And that is where they missed the jurisdictional deadline. And I don't see the Ohio Supreme Court saying, sure, we'll waive it by a day because it is a statutory deadline, it is a well-known deadline, and it's a jurisdictional deadline. So if this gets denied by the Ohio Supreme Court, I will keep you posted. And if it doesn't get denied, I will be surprised. I'm very curious. I have never seen an attorney argue, but Your Honor, leap year, because it is an odd circumstance. But this is also why calendaring is one of the fundamental things that appellate lawyers are focused on, because there are so many deadlines that are incredibly sensitive and specific. And the Court of Appeals isn't exactly malleable when it comes to those rules. They are incredibly strict. So this is on the lawyers. This means that the trial court will not be told by the appellate court at this point to consider the post-trial petition for relief. And I think after this, we will probably see, depending on what the Supreme Court of Ohio does, though I think they will follow along with what the Court of Appeal does. And when this is denied, I think we will see a petition requesting relief based on ineffective assistance of counsel. And then I think we will see this go around again. But I don't know if this is an error that can be undone. And that is not the defendant's fault. The defendant's in custody. It is not on them to determine, has this been filed? This is attorney error. And I don't see the Supreme Court granting relief and saying, oh yeah, now the trial court has jurisdiction over it based on this deadline. And I don't know on an IAC claim if there you will see the court saying, oh yes, now we can hear it because they've lost jurisdiction. If you are curious about what is in the post-conviction request for relief, not just the argument that it's untimely, let me know in the comments and we will cover that a different day. But I was hoping to go over the position of the case now. Where does Mackenzie Shirilla's appellate case rest? Well, It's before the Ohio Supreme Court to determine whether or not the trial court had jurisdiction on the 366th day when they lose jurisdiction on the 365th day. And I think they're going to follow along with the Court of Appeal. And this is going to get essentially denied. And the trial court ruling denying this as untimely will be affirmed. Her appeal on the merits has already been denied, meaning that her conviction has already been upheld on appeal. But if there's more information you are interested in for this case, let me know in the comments, because I see how many of you are interested in this, and I did not see much discussion around what the actual state of the appeals are. So I hope that this breakdown of the posture of the case on appeal is helpful. And with that, law nerds, we have a very busy week on stream. I will see you then. Take care of yourself, take care of each other. Thank you for being here, and thank you for being a law nerd. Cheers. I'll see you soon. Thanks for joining me. If you enjoyed this episode and don't want to miss updates on your favorite cases, you're going to need the Law Nerd app at lawnerdapp.com. That way you can stay in the loop on the cases that matter most to you, and you never know when you're going to catch feelings for a new case. So make sure you get it for free on iOS and Android. Thank you for being here, and thank you for being a law nerd.